Pause it here. This is the classic misunderstanding we see time and time again. There is no general law in England and Wales that prohibits photography of buildings, staff, vehicles, or security infrastructure from a public place. The prison may be a secure site, but the pavement outside it is not magically restricted. The legal test is simple. Are you standing on public land and not committing a specific offense, such as obstruction, trespass, or harassment? If not, photography is lawful. Staff saying, "Is there a law against it?" actually exposes the problem. They don't know the legal position. The burden is not on a member of the public to justify filming. It's on authorities to justify interference. Without a statutory power being cited, this is not enforcement. It's assumption.
Or against it, I think you'll find it's called public photography, which is perfectly lawful.
So, on what reasons are you recording?
I'm doing a story, but it's none of your business.
Pause here. Now we move from misunderstanding into potential misuse of police powers. The officer suggests an offense has technically been created because of alleged swearing. In UK law, swearing alone is not automatically an offense. Under Section 5 of the Public Order Act 1986, the words must be threatening or abusive and cause harassment, alarm, or distress. That requires context and evidence. Simply being told you swore does not satisfy the evidential threshold. More importantly, arrest requires necessity under Section 24 of PACE, not convenience. Officers cannot threaten arrest as leverage to gain compliance. If there's insufficient evidence of an actual public order offense, the arrest power collapses. Suggesting arrest without establishing those elements risks turning a complaint into an unlawful detention.
You can obviously understand the concern of that.
Am I being detained? You're detaining me. Are you? Are you detaining me now?
Am I detaining you?
Yeah.
I'm not detaining you, I'm just coming to speak to you.
I don't want to talk to you, thanks. Don't want to talk to you. It's my legal right. I don't want to talk to you.
Right.
I'm not committing any offence.
Right, but listen to what I've got to say then.
No, I don't want to listen to you. I don't have to.
Right. They've said that you've been telling them to F off, so you have technically committed an offence.
No, I haven't. I got the evidence.
You might have it on evidence.
Yes, I do.
But for us to investigate that,
no,
then we could have to arrest you.
No
to
way.
then witness that. Yes.
Well, you know what?
Stop it there. You would have been arrested instantly is not a neutral statement. It's coercive positioning. Police powers must be exercised lawfully, proportionately, and with clear grounds. An officer cannot retrospectively justify a hypothetical arrest as a negotiation tactic. If the legal grounds for arrest truly existed, the arrest would either occur or be clearly explained. The courts are very clear. Arrest must be based on reasonable suspicion of an offense and necessity criteria, not on irritation or reputational concerns from a complaint. Using arrest as a conversational threat undermines procedural fairness. It shifts from investigation to intimidation, and that is where complaints often become civil claims.
It does.
That's why we avoid an arrest. If I wanted to arrest you, you would have been arrested instantly, and I'm trying to avoid that.
Don't threaten me with arrest.
I'm not threatening.
Because arrest doesn't wash.
Pause this. The reference to case law is significant. The High Court in Harvey v. DPP clarified that police officers, by virtue of their training and exposure, are less likely to be harassed, alarmed, or distressed by mere swear words. That does not mean swearing is always lawful. Context matters, but it does mean the threshold is higher than many assume. For a Section 5 offense to stand, there must be evidence of genuine harassment, alarm, or distress, not simply offense taken. If the alleged conduct occurred once, in passing, and without escalation, it becomes extremely difficult to justify arrest. The law protects public order. It does not criminalize irritation. When officers understand that distinction, encounters like this de-escalate quickly. When they don't, they escalate unnecessarily.
What you need to do, I've done nothing wrong. And by the way, I did say the swearing's not an offence. Not only is it not an offence, that I could, with nobody around, I could tell you guys to F off repeatedly, and there's nothing that you can do about it. Harvey versus DPP, Judge Bean.
Right.
Judge being, it's a case that's been decided in the High Court of England and Wales. Okay? You cannot be harassed, alarmed or distressed at hearing swear words because you hear them so common, so often, and that